And my guest, welcome to former trial and appeals attorney, Dr. Tracy A. Pearson. Dr. Tracy, excuse me. Thank you so much for being with me tonight. Truly appreciate it.
Thank you so much. It's always wonderful to be here.
All right. Now, let's talk about Bo Dukes. Creates a little bit of a problem. First one being, of course, what are they going to be allowed to impeach him with? Right? We have the prospect of a possible deal. Sounds like there wasn't a deal. Anyone who's been in those rooms talking about deals, you know they're out there. You know what to expect, but they're never written down. They're never formal. So there's that. But they also have these pending charges. You know, the defense wants to use those pending charges to impeach him as well. Your thoughts on that?
These are two very confusing situations for folks who may be watching at home. When the attorney was talking about questioning the witness and being able to cross-examine the witness, she was talking about declaring the witness hostile. So you can call a witness, and if the witness demonstrates that they're hostile to your client, you can ask the court to order that witness be a hostile witness and therefore circumvent all the special rules around asking questions on direct. So for example, open-ended questions out the window, and you can ask cross-examine questions and ultimately be the one testifying as the lawyer. When it comes to impeaching on the issue of prior bad acts, the problem they've got is that this gentleman hasn't been convicted of those crimes. And so what they're trying to do is sort of bootstrap the idea of putting your good character in evidence, which is what you do every time you testify, even though he's not doing it by choice, and attacking him on these crimes that he's been accused of.
Now, I want to play some sound here from the prosecutor who had those initial conversations, Paul Belton. He talks a little bit about the statement that Bo Dukes makes, and then I want to talk about it. Let's listen.
Defense counsel asked you about whether or not the statement that Bo Dukes, or the time that Bo Dukes gave Ryan's name was after your meeting with Mr. Fox and Bo Dukes. Let me clarify. Throughout the course of your working on this case, have you learned that in fact Bo Dukes has already named Ryan as the murderer in this case to multiple people?
Yes.
And he had done that over a number of years, correct?
That's correct.
In fact, did you learn that Bo Dukes and Ryan had specifically indicated that Ryan murdered her just a few weeks after she went missing?
That is correct.
She asked you about verification. You said that there is some verification of his statement to law enforcement, correct?
That's correct.
That being Bo Duke's statement to law enforcement, correct?
That's correct.
In fact, Ryan Duke, when he was interviewed, specifically his confession also indicated that Bo Dukes had nothing to do with the murder, correct?
That is correct.
All right, so Dr. Pearson, here's my issue, right? They're having these discussions, and you hear he's told other people about this murder. Again, I don't know about his credibility in terms of not being involved, Bo Dukes himself not being involved. But the prosecutors tell him, look, we'll work with you, but if you had anything to do with the murder, then we're not gonna work with you. Lo and behold, when he gives a statement, he's not involved in the murder at all. He's just involved in the cleanup. Those are things that I feel for a fair trial, to get to the truth, this jury has to know.
I agree. I think that you do need to know what he was promised, if he was promised anything, in order to be able to question him on issues of bias, motivation possibly for testifying in a certain way, in order to get a full airing of the facts. But in that presentation by that lawyer, through those questions, they were trying to get to the point that there was no deal conditioned here on the statements that he was making, that he had been making those statements all along.
And that's fair. I mean, I agree with those comments, but at the end of the day, without this fact that there perhaps was a deal on the table, then the defense might not be able to go into it the way they would want to and impeach him the way that perhaps he should be impeached.
I'd agree with that. I mean, you know, in my experience with these sorts of arrangements is that there's some discussion to try to sweeten the conversation, to try to elicit statements on condition on a good faith effort by the prosecutor or by the law enforcement officer to make a recommendation for something to the prosecutor for a type of immunity. But there certainly has to be a written proffer in order for that to happen. And that absolutely didn't happen here.
Yeah, and without that, that does put them in a difficult position. And at the end of the day, this case appears to be shaping up as a he said, he said. At the end of the day, I can't imagine that the defendant wouldn't want to somehow, in his defense, point the finger at Bo Dukes. We know that Bo Dukes might be pointing the finger at the defendant should he choose to testify. Do you think that's the right way to go?
If you can create reasonable doubt in the minds of the jurors by pointing it at another person, then that's what defense counsel is going to do. And in many cases, that's very effective.
But let me ask you this. In order to really do that effectively, does he have to take the stand, meaning the defendant? Does he have to tell his story and paint a picture that suggests Bo Dukes perhaps was the aggressor or the mastermind or the person really behind all this?
That's a risk for him to take the stand. I think that the empty chair defendant can work. It has worked, but you have to be very, very careful about how you go about doing it. Sometimes it looks like a ploy.
Yeah, I agree. And I think it's going to come down to, again, if you don't want to put this defendant on the stand, which I don't think you do, it's going to really turn on that cross-examination, which is why there's a question as to whether the state will even call Bo Dukes. I think they've got evidence that supports this case without Bo, but then the defense says, well, if you don't call him, we'll call him. Do you think that's a good idea?
You know, you don't choose your witnesses. I've had cases in the past myself where I've been told that they were going to call the witness and then last minute had the rug pulled out from underneath me and had to call the witness myself and ultimately ended up not doing that. So there's a lot of jockeying that goes on pre-trial, and that's what we're seeing.
Yeah, could have been much ado about nothing at the end of the day. All right, stand by, doctor. We're going to take a break now. When we come back, actually, first, let me remind you guys, tomorrow,